car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. A really interesting topic coming up today. You're going to want to stick around for this. Some ground rules before we get things going. During each and every episode of the attorneys, Hollis Wright makes available attorneys standing by live to take your call. That's taking place. They're standing by now. It's an actual attorney, a confidential, all fair conversation. So at any time in the show tonight, if you would like some free legal advice, that opportunity is right there for the taking. Please take advantage of that. Also, if you'd like to join our conversation all throughout the program, ways at the bottom of your screen for you to converse with us. We always love hearing from you. Leading our conversation is the managing partner of Hollis Wright, Josh Wright. Good to see you.
You too. Hope you had a great week.
I did.
We're getting close to Christmas. Things are starting to come together for the holiday season. It is.
Right here,
100%. You know, David, one of the things that you mentioned in the intro is that, you know, there are lawyers standing by to handle calls, texts, emails, Twitter posts, Facebook. We handle all that stuff, and we answer it live during the show. So if someone's got a legal question related to this topic or another legal topic, we're happy to try and help during that time frame.
Yeah, it's a neat opportunity. You guys do a great job, all the different ways of communicating with the firm. You guys are really quick to get back with folks too.
Well, we've been doing it for a while now, so we've got it down to a science.
Good.
All right, so tonight we're going to be talking about child support, custody-related issues, things that impact a huge component and portion of our viewing audience. And Benita Jenkins is with us today. And this is one of those areas where we're not experts in this area, so we bring the experts on. She's got her own practice here in town, and she does a lot of probate-related matters, and she focuses part of her practice on support and custody and just family law-related issues. So first of all, welcome. Super glad to have you on. Happy holidays to you.
Thank you.
So how did you get into this area of the law? Because this is kind of a specialty that a lot of lawyers don't handle, and you really need to understand the way the law works and the way the statutes work. How did you get into this area of the law?
So when I first started practicing, I kind of focused in on criminal law.
Okay.
And I took a lot of appointed work. And when the PD's office came in, I was like, wow, what am I going to do? Well, it's kind of interesting how criminal law and family law kind of go hand in hand. And so I kind of merged into it that way. And I've been practicing 6 years ever since, and it's been a good experience.
So I know there is a lot of emotion when you've got couples that split and there are issues of support, and sometimes not couples that split, but just support-related issues. Sometimes there can be a lot of emotion in that. Do you find yourself being a counselor as much as you find yourself being a lawyer in this area?
Absolutely. It's very dramatic. It's very intense at times. I mean, you're dealing with children a lot of the time. So it can be high intense, high focus. So a lot of times I do have to calm my clients down and just kind of keep them focused on what the main issues are.
All right, so let's help this viewing audience understand a little bit about how the support process works. Okay. What we're talking about is child support. Explain a little bit just kind of the way the process itself works, and then maybe we'll kind of work our way through some of the specifics.
Okay, so Alabama has kind of a neat system. They use a formula-based calculation system that's governed by the Judicial Administration. It's under Rule 32, and they kind of use like this guideline chart. So there's two parents typically that are involved, and usually the non-custodial parent is the one that typically has to pay the support, but they take both parents' income into consideration when they calculate that support.
Yeah, and I've heard before something called an income sharing model. Is that kind of the process?
That's the correct
So what does that mean? You mentioned that the custodial parent generally is the one that is receiving the support, but is there an income sharing model where you take the income of both parents into account?
Yes, you use both parents' income and you use this kind of timetable chart. And at the end of that timetable chart, there's like a percentage for both parents depending on what their income is. And like I said, the one that typically has the child is the one that's receiving the income, but the one, unfortunately, who is the one that has to take care of the child is the non-custodial parent.
So answer this, because I know we get this question a ton on the show. even when we're doing other topics. So what happens in circumstances if there's a change? Let's say I'm paying child support, but there's a change in my income or I lost my job. What happens in those circumstances? Because we get a lot of those questions.
Absolutely. A lot of times I tell clients that call my office, be proactive and file what's called a modification of child support. If you've lost your job, the courts don't know that unless you file something. So it's very important to kind of beat the other parent to the punch and go ahead and file that so the court can be aware of the new circumstances.
And David, this is one of those areas of the law we talk about. We don't have debtor prisons, but this is an area of the law that if you don't pay your child support, you can get into some significant legal problems, into some trouble. There are some bad consequences, and so staying ahead of it, as Benita said, is super important.
You know, backing up just for a moment, you all were talking, kind of, this is off a little what you're talking about, but the timing, I think, is of this show is interesting to me. I have family members who divorced and, you know, split in raising of children. The holidays, especially Christmas, is a very emotional time. If you know how to work that out, and like you were saying, Josh, this is such an emotion. Talking about the raising of a child and a family and those bonds. What kind of advice would you have to our folks kind of watching over this? Because there are oftentimes things happen in this time of year that are not exactly what's planned, not what, you know, and do you kind of call for almost to take a beat and take some of the pressure off of them?
A lot of times during the holidays, a lot of times the parents split the child, if you will, and that's when it kind of comes, you know, difficult because you have to share that time during those major holidays. What I would tell a parent is to, you know, despite what you and the other person is going through, remain focused on the child, because a lot of instances I see, it really, it takes a toll on the child when they see the parents kind of in turmoil. So remain amicable. Try to stay focused on what the main issues are, which typically are the children.
I know we're getting ready to go to break. When we come back, I want to have her answer this question because I know it's important, and that's this. What happens if the two parents reach an amicable agreement on how they're going to handle child support? Can they take that to the court and offer it up to the court, and will the court agree to it? Let's talk about that when we come back.
All right, we'll pick up right there. Whenever we come back, we're heading to our first break. A good time to remind you, we'd love to have you join our conversation. You see ways to join the conversation right there on the screen. Also, if you are kind of a social media kind of person, Facebook, Twitter, Instagram, all ways to find Hollis Wright. Just search Hollis Wright and you'll find it there. A great way. The way the firm uses that really for educational, informational purposes is really cool. So check it out. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back in to the attorneys. Appreciate you being with us on this Sunday evening here with Josh Wright, managing partner of Hollis Wright, Benita Jenkins as well, talking about family law. Before we get back to the conversation, a reminder, attorneys from Hollis Wright standing by live right now. Just pick up the phone, give them a call if you would like to speak with an actual attorney. Standing by live, free, confidential, off-air conversation. Josh?
All right, so Benita, let's talk about this. What happens in circumstances where you've got two parents and they say, hey, we don't want to go by the schedule under the code, but we've got a reasonable approach and we want to put that together and we want to punt it up to the court and let the court assess whether or not they're going to agree to it. How does that work? Because I know that happens a lot.
Yes, and I love parents like that because that means they're thinking about the child. What happens in that instance, as long as it's reasonable and as long as you kind of pinpoint, you know, which parent has physical custody at what time, working out those major holidays. Most of the time, the courts that I go before accept that. Now, typically, each judge has their own what's called standard visitation schedule. Neither parent really is happy with that schedule, I'm being honest. It typically doesn't work out in the best light for the child. So I really advise parents to put their differences aside and work out a schedule that works for them and for the judge not to have to decide, because usually neither parent winds up happy.
All right, so if you are a mother, for example, you have a child, you need support, and the father is indicating that they don't want to go to court, but they want to reach an agreement outside of court and they'll pay monthly. Is that a good idea or a bad idea?
That's actually a great idea,
okay,
because in that instance, you can still calculate by the Rule 32 guidelines.
Okay.
So I definitely recommend that.
Okay. And so if there are issues, though, down the road with that where someone stops paying child support, can you still go to the court and say, hey, look, here's a deal we had, an agreement we had, but we need to formalize it now?
Okay, yes, good question. So the agreement is placed into a queue as a proposed order. So it's actually an order that the parties have to go by. It's just the agreement that they came up with. But the judge signs off on it, so it actually is, you know, mandated, and they must follow it.
Okay.
Question we've got here, what's the age limit when a person is no longer obligated to pay child support?
So the age of majority here is 19. That's when the child becomes an adult. There is an emancipation law here, but a lot of times you don't see a lot of people having that issue, but 19 is that age of majority unless parties agree to post-minority support.
Yeah, and I was going to ask about that post-minority support, like when someone, for example, goes to college, how's that handled with the court? I mean, is it the same each time or is it different per child?
So it's actually different, and the law has changed over the years. The court cannot mandate a person to pay post-minority support anymore. The parties have to agree to it. So if there is an agreement, a lot of times I tell clients, if you agree to post-minority support, make sure every I is dotted and T is crossed, because if you have some language that's kind of ambiguous,
right,
it's kind of hard to see, okay, are you talking about just college tuition? Are you talking about room and board? What are you talking about? So I just tell the clients to make sure that you put the specificities in there.
Do you recommend going to a lawyer for these things all the time? I mean, it seems to me like I wouldn't want to try and manage that on my own. I mean, and you'd want a lawyer that knows these things, because that's a great example. I mean, are you talking about books? Are you talking about tuition? You know, are you even responsible for paying for that? Those types of things, those are all issues you got to advise clients on.
Right, and you do have a right to represent yourself in these types of matters, but a lot of times the clients just don't know the jargon, don't know the legal jargon, don't know the process. So it's always good just to have a legal mind just to kind of guide you through those processes dealing with children.
Each time we have this topic, or we address topics that are similar to this, we get this question. So I want to ask it, and that is, when my child turns 19 and I have a support obligation to the age of 19, what do I do when they turn 19? Do I stop paying, or do I have to notify the court? How does that work, and what do you recommend?
Oh, thank you. That's an awesome question. No, it does not terminate automatically. It's your job to go and tell the court, hey, my child has reached the age of majority. And typically, when a client comes to me 3 or 4 months prior to the child reaching 19, I tell them, let's try to go ahead and file, because the court system typically won't get you into court until 2 or 3 months down the road. road anyways. So it's your job to file a motion to let the court know that that child has reached the age of 19.
And one other issue that comes up a lot is speak to the mothers or fathers that are behind in child support right now. You know, can you put your head in the sand? Will it go away? Do you need to manage it now? Do you get a lawyer involved? Do you throw yourself at the mercy of the court? What's your recommendation on that? Because I know you get people a lot that probably say, hey, look, I'm behind. I don't know what to do. I got to find a way to catch up. I don't want to go to jail over this. Like, how do you manage that?
There are certain ways to handle that. If DHR, which is the Department of Human Resources, if they are involved, a lot of times they are owed some of that money. So a lot of times they do have certain agreements that the parties can make to get that interest down, to get that amount down. I have clients $10,000 to $20,000 in debt, and it's affecting their whole life, dealing with credit and other issues. I tell them, hey, let's file a modification. Let's go in there to see if DHR can work something out. Let's see if the other party will agree to work something out with you, since they see that you're trying.
I learned a lesson a long time ago, David, that I've never forgotten from my parents, which was when things go wrong, you can put your head in the sand, but it will never go away. You got to manage the details. Yeah. This is a perfect example of where you got to manage the details. Allowing it to get out of control with interest, potential jail time, all sorts of things that can happen is not worth it. When we come back, I want to talk a little bit about custody and how that process works, because we've tackled support a lot, but I want to talk about custody and maybe even do some rapid fire. She can field this stuff.
She can handle
it. No question.
Good deal. All right, we're stepping aside for our final break of the evening. As we do so, a reminder of how you can join our conversation now. Just a few minutes for you to do so. Take advantage of that opportunity. More of the attorneys coming right up.
I'm attorney Bobby Bell with Hollis Wright Law Firm. In today's world, social media is all around us. It is common for many people to post on social media regarding their life and activities on a daily basis. Facebook, Instagram, Twitter, and similar social media are a great way to stay connected to others and to share your experiences and thoughts. Some seemingly innocent social media posts, however, can have devastating effects if you're involved in litigation, especially in a personal injury claim, a contested divorce, or a child custody battle. Courts regularly allow adverse parties access to the other side's social media accounts, allowing relevant posts to be presented as evidence. These rules have allowed social media to become a hotbed of information in the litigation world. In fact, we are seeing more and more preservation orders issued by courts requiring you to collect and save any and all social media activity. Therefore, it's advisable that even before there's litigation, lawyers should advise their clients that social media content may be discoverable. Here are a few helpful tips. 1. Do not post anything about the case. This includes posts regarding conversations or meetings with your attorneys, remarks about your injuries, negative remarks about the opposing party. Do not post anything you would not want read in open court to either a judge or a jury. 2. Avoid new friend requests from people you do not know. Many law firms and insurance offices may attempt to have employees follow you on social media in an attempt to gain information. 3. Limit adding new photos, check-ins, photo tagging, etc. Seemingly innocent posts may be used against you. Regular check-ins at restaurants, parties, or other events with friends can cast doubt on any claims of loss of enjoyment of life, pain and suffering, or emotional distress, since you appear to be living life as usual. 4. Increase your privacy settings. Many social media sites frequently update and change their privacy settings. In the litigation context, it is possible you may have to preserve and present anything you posted. Therefore, we encourage you to be smart and careful when using social media. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WBTM 13.
Welcome back in to the attorneys. Our final segment here. Time always flies on this show. Here with Josh Wright of the firm, managing partner of Hollis, Wright, and Benita Jenkins talking all about family law. A question we've got here for you, Miss Benita. What happens when one person violates or doesn't follow an order setting a custody visitation schedule?
So basically, the fancy term is what's called a rule nisi. That's a fancy word for contempt. So what would need to happen if one parent is withholding that child or doing something where they're not getting all their visitation, I would ask them to go to the court or hire me and file what's called a petition for a rule nisi.
How does the process work with physical custody versus just getting visitation? I mean, does the court generally set that, or is it agreed to by the spouses? How does that work?
So either or.
Okay.
So there's two types of custody here in Alabama that typically the parties deal with. That's physical custody, and of course that's kind of self-explanatory. That's the time, allotted to each parent for that child. And then there's legal custody. That's where the parents have decision-making capabilities for that child. That can be anywhere from extracurricular activities to civic activities to, of course, medical and school activities.
So how many times do you get a call that says, all right, here's what our custody arrangement is, or this is what you got for us, but so-and-so's not following this? And I mean, are you filing these contempt petitions a lot? Does that happen a lot?
Yes.
Because I would imagine there's a lot of emotion in this too when you're dealing with custody.
Absolutely, especially around the holidays.
Okay.
For some reason, people kind of forget the orders of the court around the holidays. So they want to take a day or two after Christmas when they weren't supposed to, have that. So I have a lot of calls with different things dealing with withholding children around the holidays.
How about, how does school work? Is school going to be based on where the child spends the majority of their time,
Yes.
even if they have joint custody? All right, I just kind of trying to figure that out.
So even in joint custody situations, most of the times the judges pinpoint what's called a primary parent. Okay. That primary custodian is the one that has the child typically over 50% of the time. And that's the one that enrolls the child in school. That's the address that the child uses for school. And they're the ones, let's say you don't agree to the school choice or you don't agree to the pediatrician, they can be the tiebreaker, if you will, and that decision-making capability gets kind of trumped by that primary parent.
What's the status of grandparent rights? We get this question a lot, and I know the law's changed over the years. It started one way, and then it went another way, and then maybe came back to where it started. Does it stand in the same place it's been for a while, or kind of where is that?
So the law changed a couple of years ago on grandparents' rights. It's very much a law here now.
Okay.
It's still kind of testing the waters a little bit. I haven't had too many calls on it, but I do see a lot of grandparents' rights being enforced in dependency situations where DHR had to uproot the child from the parents due to abuse situations, drug allegations. A lot of times you have the grandparents having to step in and get custody of the children.
Yeah, and a lot of what we see with questions that come in that now I'm saying so-and-so's withholding this child from me and I can't get the child, and so do I have rights? And so the law has changed back and forth several times, and so we try and keep abreast of what the law is to make sure we can advise them properly. But I understand it. I mean, as a grandparent, you want to make sure that you're getting your visitation.
And such a vital role in the child's life as well. Question we've got here, is there anything that someone can do when one person tries to move out of state and the other parent doesn't want the child to move?
Yes, there is. So there's an Alabama Relocation Act that's in place that has to be attached to all custody orders here in Alabama. Basically, that's kind of like a guideline that the court has to give you and that each party has to follow. The primary parent has to give the non-custodial parent or the secondary parent a certain time frame on, hey, and it has to be written on, hey, I'm about to move and this is where I'm moving with the child. And the non-custodial parent has 30 days once they receive that written notice to file something with the court, and typically it's a motion to object to the relocation.
Okay. So the court's still involved with that process too?
Yes.
So tell me this, how does the court handle, let's say you got spouses, one party may have contributed a little more than the other to a divorce because of maybe a substance abuse, infidelity. Is that weighed in custody? Meaning, do the family judges weigh who the wrong party was, or who the party was that may have contributed more to a divorce, for example, in deciding how custody is handled? I've always wondered that question.
Absolutely. The domestic relations judges typically look at all circumstances that are brought before them. Infidelity, for instance, like you said, typically the court kind of deals with that when looking for like alimony situations, but it becomes a custody situation when the person that did the adultery had the child around the mistress or the mister. So that can become a factor in your custody and how the courts kind of determine which parent has the best decision-making capabilities for that child.
How about during the time that you have your custody? Let's say you have custody of a child for the weekend. Can you bring a non-relative around the child, like a boyfriend, a girlfriend? Because I know people start to date at different times.
That's a good question.
How does that work? And does the court get involved in that if there's not a big dispute over it? I mean, how does that get handled?
Yes, because you have to look at it. In divorce situations, the divorce can be pending for years.
Yeah.
So, of course, the courts kind of know that, parties move on.
Yeah.
But I have almost all of my divorce cases within the last 2 years. There's a little paragraph that is put into the divorce decree that says that if you're in another relationship, just don't have that child around that person overnight. So no overnight guests while the visitation is occurring. And that usually fixes it.
Yeah.
We are just about out of time, a couple of minutes remaining in the show. I want to give both of you the opportunity for a final thought. And Benita, if you would, you go first, please.
Basically, my advice to anyone that is going through a divorce, going through a custody battle, if you will, just call any attorney. It doesn't have to be me, but just to know your rights. It's just very important to know what you can get, what you can't get, and what the courts typically decide on.
Number one, if you have an issue that relates to divorce, custody, support, Benita is a great example of an expert that we bring on the show that knows what she's doing, right? And she's solid at this. And so, my recommendation would be do not put your head in the sand. If you want to make sure that you protect yourself, protect your relationship with your child, manage your support correctly, you want to get a lawyer involved and get that lawyer involved as quick as you can. Lawyers are not super expensive in that area of the law, and it can be very expensive for you long term if you don't have a lawyer involved. So it's worth the effort, time, and money to get somebody involved early and get them involved in that process quickly. Great job.
Thank you.
Did an awesome job.
Thank you so much.
Thank you, Benita. Thank you, Josh.
Thank you
Good to
so
see you.
much. Good to see you.
You stay right there. We're wrapping things up here as we kind of wrap up the show. A couple of reminders. Even though the attorneys may no longer be standing by, you can still get in touch with the firm. They return every email, Josh?
Every email.
Within 24 hours.
Yep.
All right, good deal. So get in touch with him. Ready to speak with you. Thanks so much for being with us. We'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.